I'm Carson Jeffries, one of the founding partners of the Mold firm. Our attorneys have more than 20 years of combined experience representing homeowners and tenants with their mold and water loss claims. I want to take this opportunity to apologize in advance and prepare you for our intake process because it is a lot of work and very comprehensive. We ask for a lot of information because mold cases are hard to prove and very complex. If mold cases were easy money, then ask yourself why you see dozens of billboards, TV commercials, and website advertisements for car accident attorneys, but almost none for mold. Anyone who claims you have a slam dunk mold case is either not an attorney, has not worked on a lot of mold cases, or is trying to tell you something. I also want to be honest with you that even if you give us all the requested information and we engage you as a client, your case will still require a lot of work and take several months and possibly even years to conclude. You should also know that while many of our clients are happy with how their case is resolved, not all cases reach a successful conclusion. That being said, through years of handling dozens of mold and water loss claims, our attorneys have identified certain information, evidence, and documentation that we feel are very important to proving the legal elements of a residential mold and water loss claim. Through our intake forms and process, we will try to collect that essential information and documentation from you. For purposes of this video, when I talk about a mold case or a water loss claim, I'm referring to a dispute or lawsuit where you, the tenant, are claiming that your landlord negligently failed to maintain or repair the rental residence in a safe and habitable manner, resulting in flood or mold damage to your person, your possessions, or caused you some other measurable harm. Each mold case is different, and during the course of representing a client, we collect lots of information and evidence. Right now, though, I'm going to list and explain some of the core legal elements and related evidence or documentation that we request from every potential mold client at the outset of our intake process. First, we request a copy of your lease agreement. This document explains many of the duties or promises that you and your landlord have made to one another, such as what is rent? Did you pay a security deposit? Or who should you contact if your apartment or rental home has a mold problem? Second, we ask for documentation or evidence proving communications between you and your landlord or property management about the mold, flooding, or other maintenance issues in your apartment that eventually caused the mold growth, such as a roof leak or a leaking water heater. We ask for this because Georgia law generally requires that we show that your landlord had prior notice of the mold or water intrusion problems, but failed to fix them after being given a reasonable opportunity to do so. I also want to add that good communication and cooperation with your landlord about needed maintenance repairs is just good practice and a great way to avoid a mold problem in the first place. We ask that you provide this evidence or documentation in at least one of four forms. Either a copy of a certified letter to your landlord or property manager with proof of a mailing receipt, a copy of a code violation or warning from a code enforcement or housing authority official to your landlord or property manager, a copy of a work order that you submitted, or an email, text message, or letter from your landlord or property manager referencing the maintenance repairs, water intrusions, or mold. I want to be clear right now that text messages or emails just from you to your landlord or property manager without a response from your landlord or property manager acknowledging the repair items or mold are generally insufficient. Verbal communications are also insufficient because it is very likely that your landlord or property manager will deny the conversation ever occurred, and we want and need strong evidence. If you do not have these documents, then please visit our website, www.moldfirm.com resources page, for more details on providing notice to your landlord. Third, we also ask for a mold report and photographs that help us to demonstrate that your landlord failed to repair the mold or water intrusion problems properly or in time to avoid mold from developing in your residence and causing harm to you or your possessions. A mold report is also critical to determining if your apartment is safe and habitable for you or your family to continue living there, or if you have been constructively evicted from your rental residence. This is very important because if you break a lease and a court or jury later finds that the apartment was suitable for occupation or did not have a mold problem, then your landlord can seek penalties such as past due rent and late fees for your breaking of the lease agreement. For more information on getting an air quality or mold report, please visit our firm's website, www.moldfirm.com's resources page. We will also be requesting documents, receipts, invoices, estimates, or other evidence of your mold-related damages. This is because we are not a law enforcement agency that imposes criminal penalties on your landlord or forces him to make repairs. In a civil mold case, you are entitled to seek financial compensation to reimburse you for any mold-related injuries and losses that you suffered as a result of your landlord's failure to maintain your rental residence in a safe, habitable, and mold-free state. You must show damages, and these damages must be proven with reasonable specificity. Proof of damages might include hotel receipts for obtaining an alternative and safe hotel or housing, a receipt for having your furniture placed in storage or remediated of mold. For more information on the types of damages you might be able to seek in a mold case, please visit our website at www.moldfirm.com and its resources page. The need for all this strong evidence is also why when you are in a dispute with your landlord, you should always keep copies of all emails, text messages, letters, proofs of mailing, photos, and other related documents. We deeply apologize, but without these mission-critical documents, we probably won't be able to help you and will have to decline your case. This isn't because we don't care, but because we don't want to waste your time or money or promise something that we likely can't deliver due to the rigorous evidentiary requirements in a mold case. There is some good news though. First, if you visit our mold firm's website and our resources page, you will learn more about the specific evidence or documents you are still missing, and then you may still be able to obtain them. Once you do, you can resubmit your information to our firm. Sometimes though, you may not be able to get this missing information. For example, you may be missing a mold report and no longer have access to your apartment. Or you may be facing an immediate eviction and do not have the time to go through our intake process or to reapply. Fortunately, in these or other cases where Mold Firm is unable to help, we provide resources on our www.moldfirm.com page to assist potential clients with alternative solutions and programs.